you know, this position, the state is saying blunt force trauma, and I agree to natural causes after speaking to Mr. Gregor, and I kind of agree with him. I'm sorry, Judge. And I kind of agree with him. You know, you don't generally see a child dying from natural causes. So would it be, we would prefer if we said what Baden's going to testify to is the onset of pneumonia and then sepsis.
The state objects. It specifically talks about causation. So there's cause and manner of death. We all know that. And there's 5 different causes of death. Or there's a number of causes of death, but one of them is natural.
Manner of death.
Manner of death, yeah. So
I'm using my words.
Suicide,
yes.
Homicide.
Correct.
Natural, accidental, or undetermined, I believe.
In fact, I'm going to take out blunt force trauma and say murder and natural causes.
Sure, we'll say murder.
Well, but you said you were concerned about natural causes. You want to leave natural causes in there then? Or?
Well, if she's arguing that it's got to be the 5, one of those 5, I mean, I was just saying that if they're going to say blunt force trauma, why can't we say what Baden's going to testify to, the onset of pneumonia and sepsis?
I mean, certainly going to say that in closing.
Right, well, obviously, I'm going to say it in my closing.
Well, if
I would hope.
I shouldn't say murder, I should say homicide then, if I'm going to pick.
Well, Judge, I mean, the onset too, like you're putting facts into the case. In terms of cause of death, it's blunt force trauma injury. The defense is arguing that this is a natural death. I don't know as a simpler way to say that. Like, the purpose of that is just to give an idea to the jury. It's not to impose the defendant's argument or their proposed testimony into the jury charge.
That's fine, Judge. Then we don't have to impose on the jury blunt force trauma.
So it's just homicide versus
Natural causes.
No, Judge, I believe that our cause of death is blunt force trauma. Their cause of death is
Sepsis.
sepsis. So you want to say sepsis? Then we could say we don't have an objection to the word sepsis, but I think it's onset of pneumonia is where we start getting into that.
I personally don't see the difference. But, I mean, the two go together. You're not going to get sepsis if he didn't have pneumonia.
That's not true, Judge. Sepsis, there's a lot of different things that can be caused by sepsis.
He's not saying it's any other infection other than pneumonia.
Well, then we'll just go with what state says it's a homicide, and then he says it's natural causes, because the state does not think it's fair that he gets to put his argument into the jury charge. There's many different things that could happen because of sepsis, and that's but it's blunt force trauma injury. That's our cause of death. It was testified as to an expert. He shouldn't be allowed to put his argument into the jury charge. Right, the state's not asking that we put lacerations and all of this. It's just blunt force trauma.
Charge entitled Murder, Aggravated/Reckless Manslaughter. Last revised June 13, 2011. Page 3 of the model talks about where there's a causal relationship. If there's no causal relationship, there's no dispute as to the causal relationship, or a causal relationship's not an issue, such as you have a shooting case and we all agree the person was shot and killed. It's just a question of, is the defendant responsible for that? You don't have to have a special section on causation. Here, that's not the case. So we have the section before this, it's a top of 20, causation has a special meaning under our law, and we describe what is known in the law as, quote, but for, end quote, causation, meaning but for the defendant's conduct, Corey Micciolo died. And then the model continues. There's a section on whether someone's removed from life support. That would be not applicable here. And then the model has a bold-faced section in parentheses where the defendant and the state offer contrasting factual theories of causation. Each version should be summarized for the jury, and it cites a case. State versus Martin, 119, New Jersey, 2 at page 18. Let's see what Martin says. So Martin appears to require a section which is system incorporated into the model charge, because this Martin case is from 1990. Here, the court had failed to instruct the jury the defendant would not be liable for felony murder if the death was too remote, accidental in its occurrence, or too dependent upon the volitional act of another, which is all that's already in our charge, right above that. Let's see what else the case is. The court there, this was an arson case. The defendant's alleged to have set fire and whether or not he's responsible for the death. The court in Martin said a further deficiency was the failure of the jury charge to relate the conflicting factual versions to the legal issues. Causation, like criminal knowledge or intent, is often a nettlesome proposition to explain to a jury. The explanation, however, is essential if the jury is to apply the dispositive legal principles to the facts. And it cites some case law. Otherwise, a jury may not be able to evaluate the facts under the appropriate legal standard and thereby determine whether the defendant is guilty of the crime charged. It is not always sufficient simply to read the applicable provision of the criminal code, define the terminology, and set forth the elements of the crime. Particularly when the trial projects conflicting versions of the facts, the court should mold its instructions to the factual hypotheses of the parties. An abstract statement about causation or the defendant's state of mind is not nearly so useful as one stating the same idea in the context of the various factual alternatives projected by the parties. Unfortunately, in attempting to explain causation and the defendant's possible mental state, the trial court failed to explain how the evidence could affect those elements. I read from the case, although I did omit various citations. So here we clearly have a disputed causation. This is unlike many murder cases where there's no dispute as to causation. The question is the defendant responsible, or did the state prove the defendant's culpability beyond a reasonable doubt? Here we have that issue, but we also have, is it even a homicide? So, I mean, as long as I couch it in terms of the state argues X and the defendant argues Y, I'm not drawing either side's attention to some particular evidence, as long as I'm doing it on balance. But it would seem you're both entitled to do that here, and I don't think you need to limit it to the 5 manners of death. The state alleges homicide, defendant alleges natural. I don't think you have to be that brief.
Judge, I think Martin specifically actually says that. It says even in the absence of a request by his trial counsel, defendant is entitled to a charge consistent with his version of the facts.
Right, and that's probably why the model was then amended to add this language that you have to tailor it to the facts of the case, particularly in a case like this where causation is an issue.
Judge, when we were talking about it before, defense counsel agreed that's how it was going to be done. If we're going to do it another way and we're going to be able to provide a statement, then we're going to have to request that we're going to have to write something and submit it to the court then, if we are allowed to give a broader explanation.
Keep in mind, you're both going to be able to argue in
Right.
summations what you think the evidence shows.
Exactly. But we just want to make sure that it's balanced, Judge, as what the case law says.
I think you should both try and work on a joint statement then. You know what, each know what the other one's alleging. So I'm fine with here the state alleges Corey died from whatever you claim he died from. In contrast, the defendant alleges Corey died from whatever you claim he died from. As long as there's a rational basis in the evidence or the testimony to say that, I'm not directing the jury's attention more heavily to one side or the other.
Right.
But I was kind of hoping to be able to give you a final version here today, but we still have plenty of time if you want to do that. You want to move on to the jury verdict sheet and circle around back to this later on?
Whatever you want, Judge. I'm here all day.
All right.